Some people assume that a lawyer's main job is to help his or her client enforce or protect their rights. But many believe that a lawyer has an additional obligation, helping the client select the best way to handle the case. Often this means that rather than assuming the matter will be litigated, the lawyer should help the client select the best method of dispute resolution, the one that is most appropriate given the client's legal position and the client's other interests. The lawyer who wishes to discuss dispute resolution options with a client or with opposing counsel may have two concerns. First, the lawyer may not be clear about the various methods of dispute resolution and the advantages and disadvantages of each. Second, she may fear that by raising non-litigation alternatives, she may give the idea that she is afraid or unwilling to litigate. This videotape is intended to illustrate some possibilities and problems in helping a client select a dispute resolution method and persuading an opposing lawyer to participate. There are two parts. Part 1 shows a lawyer interviewing her client and counseling the client about alternative methods of dispute resolution. Part 2 shows the same lawyer discussing these alternative processes with opposing counsel. All the scenes in this videotape are based on a hypothetical case. Here are its facts. The Daily Bugle, the only newspaper in its metropolitan area of 500,000, recently published an article that mentioned John Roark, M.D. Dr. Roark believes that the article defamed him, and he has filed a suit for libel against the newspaper, its publisher, its editor, and the reporter who wrote the story. The article focused on a fire, which it described as the fifth in a series of recent fires that destroyed apartment buildings located in poor neighborhoods and owned by absentee landlords. The article included a statement attributed to a tenant that, quote, he had tried to get the owner of the property to fix a broken boiler in the building's basement, close quote, and that the building had been without heat for 35 days. Then there were two sentences on which Dr. Roark bases his claim of libel. The first was, the destroyed building is owned by slum landlord Dr. John Roark, county property records reveal. Dr. Roark is a prominent orthopedic surgeon. The second statement read, a source in the state fire marshal's office indicated that the office is not ruling out the possibility of arson because it is not uncommon for owners of tenements to intentionally burn them to collect insurance. Dr. Roark is demanding $250,000 for injury to reputation, lost income, humiliation, and pain and suffering, and $1 million for punitive damages. The defendant's answer is due in 2 weeks. The first scene is an interviewing and counseling session. The lawyer is Dana Fryer, and the client is the editor of the Daily Bugle and one of the defendants in this case, Charles Warner. In an interview, the lawyer has two main jobs. One is to build or maintain the client's trust. The other is to gather information about the facts and the client's situation. In other words, to clarify the problem or problems. In counseling, the lawyer's job is to help the client select the best way to approach the problems.
Charlie, I've reviewed John Roark's complaint against you in the Daily Bugle. And the first thing I want to do is get a better sense of some of the matters alleged in the complaint and if you are in the newspaper's position with respect to Dr. Roark's allegations. Then I think we can review how this suit is likely to play out in litigation and what other options the parties might have to try and resolve this dispute. First, I want to discuss the statements in the complaint that Dr. Roark alleges are defamatory.
The lawyer first inquired about Dr. Roark and learned that he was well known in the community and a board member of several charitable organizations, but that he had not sought publicity. Next, she asked about the bases for the two allegedly libelous statements. Her client explained that the statement from the fire marshal's office was accurate, based on his review of the reporter's notes, and that it was extremely important to protect that source. As to the statement that county property records revealed that the apartment was owned by slumlord Dr. John Roark, the editor explained that the reporter had not actually checked out the ownership. Instead, facing a deadline, he relied on a tenant's assertion that the building was owned, quote, by a rich Dr. Roark and other doctors, close quote. After some questioning, Charlie also explained that the reporter, Terry Ives, had previously written an article mentioning Dr. Roark's son and indicating that he had been involved with drugs. As we continue with the interview, Charlie has just told Dana that Dr. Roark had telephoned him after the article on the fire appeared.
Now, you said you spoke to Dr. Roark, and this was after the article appeared, after he had spoken to the reporter.
Yes, yeah, he called me.
What exactly did he say to you? Did he indicate exactly what he wanted from the paper to you?
Yeah, he called up. He was reasonable at first, and he said that you know, he really resented being referred to as a slum landlord, and that he wasn't and was a limited partner, and which sort of you know, made me raise the red flag at that point, because I was concerned. And then he went on and said that he was a good citizen, and he really resented the implication he was burning him down, etc. And then he got a little bit hotter, and not yet angry, but hot a little bit. I'd say his voice raised a little bit, and demanded a retraction. And then he said, "I must have a retraction." He started to get a little hot about that, and demanded a retraction. And I said that, well, you know, I'm sorry he was upset, but the story was essentially correct. The quote was correct, and I would not run a retraction, and I stood behind the reporter. I hadn't talked to Terry at this point, so I didn't know all the facts. I mean, I just heard his side of the story, that he was not a full owner. So naturally, I had to back the reporter in this. Right. So then I talked to Terry.
Yeah, but did he say to you, did he complain at all about the treatment he received from the reporter when he called the reporter?
Yeah, he said that Terry was really, nasty to him, and said something about, I defend my First Amendment rights, and the story's true, and that was it. And, that bothered me, because I think Terry really lost an opportunity to get his side of the story at that point. I mean, I think Terry was wrong. I think he was defensive. Maybe he was defensive because he knew he hadn't done a good job, but in digging out the facts in the first place. But that really upset me about Terry, and I've talked to him about it. I mean, I've had a very good heart-to-heart with Terry on this, because I don't think he did a particularly good job in getting the facts. But I still have to back him.
Yeah, I understand that. Well, from your discussion with Dr. Roark, could you say that you got a sense of what his real beef is in connection with this, or what he really wants? Is he concerned about monetary loss, or does he strike you as being concerned primarily about restoration of his reputation?
Well, it's hard to say. He was upset. He was angry. I suppose the notion that clients may not come, I might cancel appointments or something, maybe it's probably reputation, I would guess. Now, it's hard to say, because a lot went on in the conversation.
Well, all right, tell me, Charlie, what is your and the publisher's position with respect to the claim? I mean, how do you feel about it?
The editor explained his dilemma. The new publisher was worried about a recent decline in revenues and would not want to spend much money to defend this lawsuit. On the other hand, the newspaper was threatened with about 2 lawsuits each month and was actually sued several times during most years. So it was important to him to maintain a strong position so people wouldn't think the newspaper was an easy target. Accordingly, he said that a retraction was out of the question. Besides, this was a First Amendment issue, and he was counting on his lawyer to protect the newspaper's reputation.
Okay, listen, I agree with you, and we're prepared. As a matter of fact, we're getting our answer together now, and we're prepared to go to the mat and litigate this as we have other cases.
Good.
Aggressively and ferociously. Let me, I think, now just give you kind of an overview of what I see as the strengths and weaknesses of both sides' case in litigation, because this case is a little bit different than some of the others that we've handled for you.
Why?
Well, let me run through that, and I'll explain that to you.
Now the counseling portion of the session begins. In counseling, the lawyer's obligation is to educate the client so that the client can decide on the best method of approaching the case. Here the lawyer reviewed several methods of dispute resolution. She began with litigation and first explained the client's legal position by setting out the elements of a cause of action for libel. To establish this cause of action, the plaintiff must prove first that the defendant published a defamatory statement about plaintiff. Second, that the plaintiff suffered injury. Here, in addition to harm to Dr. Roark's reputation, Roark's lawyer had indicated that several patients canceled appointments shortly after the article appeared, and that this was a direct result of the article. Next, the plaintiff would have to prove that the defendant was at fault. Because Roark probably would not be deemed a public figure, he would only have to prove negligence, which would be a jury issue, and would not have to prove actual malice or common law malice. Nonetheless, Dana thought the plaintiff's lawyer would try to persuade the jury that the reporter had a grudge against Roark. She said there was a significant risk that the jury would be sympathetic to Roark and find for him. However, if that happened, the defendants would have a good chance on appeal. The lawyer went on to explain that truth is a defense in libel cases, and that there was some chance that they could prevail on such a defense, given that Roark was at least a part owner. Finally, she said that although the actual damages in this case probably would be nominal, or at worst relatively low, punitive damages were available in this state. To get punitive damages, Dr. Roark would have to prove actual malice, and although that would be difficult to do in this case, there was an element of risk. The lawyer then helped the client consider some other aspects of litigation.
Well, let me just run through a couple other facts that we should consider before we actually, move on to consider litigation versus possibly other options. Cost is an issue that you raised that's of great concern to the paper. And as you know, the paper's insurance policy contains a $100,000 loss retention, which applies to defense costs as well as claims.
Yeah, I know.
And that means that even if the paper wins, it's going to pay the first $100,000 of defense costs.
I advise them not to get that kind of a policy, but, well, here we are.
Well, typically that's what's happening today because of the cost of premiums, as you know, are so high that it doesn't make sense otherwise. But legal fees in this case are going to run well above $100,000. So that money is going to have to be paid out by the paper, even if the end result is 100% in the paper's favor. There's also the risk of punitive damages, and there are some important non-financial reasons why you might want to avoid litigation. Because of the factual issues in this case, because of the situation over Terry's lack of investigation, issues like truth and fault are going to be jury issues, and I think it's going to be very difficult to succeed in a summary judgment motion on those issues. The other thing is you are going to be subject to extensive, intrusive discovery, particularly on the actual malice issue, and there is the problem of the source that we discussed earlier. To really completely evaluate the risks and more specifically what the likely outcome here is, we would need additional discovery and additional discussions.
Well, if it goes to trial, that'll be public, so the fact that we didn't do a good job reporting.
That's right.
And it could even reflect on me as an editor, and that concerns me a little bit.
After analyzing the client's situation in litigation, the lawyer turned to several other methods of dispute resolution. First, she described arbitration, a dispute resolution process that, like litigation, is binding. She went on to describe several non-binding dispute resolution mechanisms: the summary jury trial, mediation, and the mini-trial.
Well, Charlie, we've reviewed the pros and cons of litigation and the risks and rewards and the possible problems and advantages, and I think considering the interests of the paper and your interests and even the interests of Dr. Roark that we've possibly identified, I think it would be worthwhile just to discuss for a few moments some possible alternative ways of perhaps being able to resolve this dispute other than litigation. And I'm talking about discussing some alternative dispute resolution procedures.
Well, what do you mean? I don't understand.
Well, the term alternative dispute resolution, or ADR, refers to procedures which can be binding or non-binding for resolving disputes through the assistance of a third-party neutral who is chosen by the parties. The procedure that's probably most familiar to you is arbitration.
Yeah.
Arbitration, of course, is normally a binding procedure.
Right, like in the sports.
That's right, but it's
deal.
used for all kinds of disputes as well. And arbitration, of course, involves the parties selecting a neutral, an arbitrator, who decides the case. the process is suffers from the same problem as litigation from your perspective, in that the outcome is not predictable. And
no, the owners always lose those arbitrations.
Well, in the sports situation, right? But also, opportunities for appeal are much more limited than in litigation. So I think arbitration is not a procedure that would be of interest to the paper. It's not one that I would recommend, and I don't think we really have to discuss it. What I do want to discuss are some of the non-binding procedures in which the parties choose a third person to help facilitate a resolution. The important thing from your perspective is that these proceedings are confidential.
Yeah, absolutely. We have to have confidentiality.
Yeah, I know that's very important to you, and we would insist as a requirement for agreeing to enter into any proceeding of this kind, that nothing that's said during the proceeding by any party would be able to be used in any other proceeding, in litigation, or for any other purpose for that matter. Even the fact of the proceeding, we would insist that it be.
So they wouldn't look at the reporter's notes, for instance?
We would, well, no. There's no discovery as of right in any of these proceedings. The parties write the rules.
Oh, really?
Yes. If the parties feel that prior to engaging in one of these proceedings, they need some limited discovery, they can agree to that. Mm-hmm. But I think in our case, we would be very resistant to any discovery. The couple of proceedings in particular that I just want to explain to you, and then I'll tell you which way I would suggest that you go if you think this is a route that you're interested in following.
But I do have options.
You absolutely have options. The options are really as broad as your imagination and my imagination. The first of the non-binding procedures that I want to explain to you, Charlie, is called a summary jury trial. And that's a procedure that's normally conducted under the auspices of the court, whereby the parties agree to submit their dispute to an advisory jury that's impaneled by the court. The parties' attorneys make summary presentations of their case to this advisory jury, and these summary presentations are normally in the form of an opening statement. And the jury renders a verdict. It's an advisory verdict. It's not a binding verdict. There are, Dr. Roark would be at a proceeding of this type, as would a representative of the newspaper, either yourself or the publisher, or both of you, and you would have an opportunity to question the jury as to the reasons for their verdict. And what it does is it gives the party an understanding as to how a jury might decide the case. The problem with this procedure from the newspaper's perspective, as I see it, is that jury verdicts are often overturned, and if this verdict was favorable to Dr. Roark, it could harden him in his position, encourage him to be very aggressive about the litigation, dig in his heels, and it's really not a realistic predictor, in my view, as to how the case would come out.
Because we do have a good case, and I think we'd probably do all right.
You do have a good case, but I think that this is not a procedure that we should even consider, and as a matter of fact, I would not even mention it to Roark's attorney in explaining to him what the options are as I see them.
Good.
The other two procedures are mediation. Mediation is the first. Mediation is a process in which the parties will select a neutral with mediation experience who has no independent authority and does not render a decision. What the mediator does is he meets with both parties, normally first in joint session, and we'll hear a presentation by representatives of both parties of their positions, after which he will generally caucus separately with each of the parties. And his purpose in doing so is to try to ascertain what the underlying interests of the parties are, what their real concerns are, so that he can see where there might be common ground in bringing the parties together. Everything you say to the mediator in private session is confidential. The mediator will not disclose to the other side anything that you've said to him or her unless you agree that that can be disclosed. So you can feel comfortable that the mediator can be told about your concerns, and the mediator will explain to you how he thinks those issues may impact on the ultimate outcome.
That sounds good.
Okay.
I like that guaranteed confidentiality. Only one person involved.
The lawyer explained that in addition to maintaining confidentiality between the parties during the mediation, because of a state statute, the mediator could not be required to testify in a trial relating to this matter. She also noted other advantages of mediation. It can be conducted expeditiously and at relatively low cost. At this point, the lawyer directed the discussions back to the needs of the parties.
Well, but you're concerned about the fact that you're not real happy about the way this article was written and the way the reporter handled it. And my understanding from our earlier discussion is you would rather that those facts not come into public view.
You bet.
And Roark, he has an interest in clearing his name, and it's going to be very difficult for him to accomplish that through litigation, at least not for many years, because it's going to take that long for this case to get through the courts and the appeal system, even if he were to win. And mediation may afford him an opportunity to clear his name, if you're sufficiently comfortable with taking some kind of action.
Charlie said that a retraction was out of the question, but that he would consider publishing an article that would include Roark's side of the story and therefore might help rehabilitate his reputation. Dana noted that the dispute resolution processes which permitted direct contact between the parties offered possibilities for working out some kind of agreement along those lines.
Again, I can't tell you now that will happen, because that's what the purpose of going through this would be.
So I'd, in a sense, be able to negotiate with Roark. See, I think maybe if I could talk to Roark, even though at this point I think he's unreasonable and I don't like the guy, on the other hand, I think his lawyers probably wants a lot of money, and maybe I'd have a better chance with Roark in this kind of a situation.
Yeah, I think you're absolutely right. That's one of the reasons why parties engage in these procedures, is it does give them a way to speak directly to the opposing party instead of everything going through their attorneys. And there are times when that can help facilitate a settlement. I've heard through the grapevine, I've done some investigation, that Roark is a reasonable guy. That he's really not a hothead, maybe only as concerned as your newspaper.
Well, everybody's a hothead when the media is concerned, believe me.
But I think you'll have to satisfy yourself about that yourself and see how comfortable you are. And the other thing you have to understand is I will be there at this proceeding.
Good.
Lawyers will be present, but not directly involved in the negotiation, but available to consult and evaluate whatever appears to be coming out of this mediation process.
Dana then explained the mini-trial, in which lawyers make abbreviated presentations to a panel consisting, in a case like this, of the plaintiff, a defendant, such as the editor or publisher, and a neutral advisor, a lawyer who is an expert in the relevant area of law and acts as chair of the panel. After the presentations, the panelists can ask questions of the lawyers, and then the two parties go off together and try to negotiate a settlement in light of what they have learned in the mini-trial. During this negotiation, the parties are not accompanied by their lawyers or by the neutral advisor. While the parties negotiate, the neutral advisor prepares her or his opinion of what would happen if the case were litigated, but does not show this opinion to the parties unless they request it after they have failed to negotiate a settlement. After she explained the mini-trial, Dana went on to suggest a specially designed process that combined a mini-trial with mediation.
Well, let me explain what happens after that. These summary presentations in the questioning is the parties then go off and try to negotiate by themselves. You will have heard both sides of the story, and if you're both reasonable and can reach a meeting of the minds, that's great. If you can't, then and this is where I think I would combine some of the elements of a mini-trial with some of the elements of mediation. You can request the neutral to mediate your dispute, to serve the functions that I described earlier of mediator, and to caucus with you individually.
So let me just get this straight. Okay. It sounds to me like the last one, the mini trial. If we went that route, at least I would be able to get a sense of the case that they were presenting, and get a sense of the lawyer, and particularly Roark, before I started the negotiations. That's right. And then I could perhaps talk to Roark and see, well, which one do you think?
In recommending a dispute resolution process, the lawyer took into account the legal positions of both sides as well as information she developed in the interview about their underlying interests. She recommended a process that was customized to suit the unique features of this case. It was a mini-trial with an option for the mini-trial advisor to mediate at the request of the parties. In Part 2 of this videotape, we see Dana Fryer meeting with the plaintiff's lawyer, William Turley. Her dilemma is this. She wants to propose an alternative dispute resolution method to an opponent who knows nothing about such options. He is likely to be suspicious, and he may initially think that because she is discussing settlement, she must think her case is weak.
Bill, I appreciate your coming over. As I told you on the phone, I've had an opportunity now to review your complaint, and I've met with my client, and I've done some investigation. And I'm personally extremely confident that the paper has a very strong case, and that it's going to prevail in this litigation. And as a matter of fact, my marching orders, which I received this morning, are to litigate this case to the hilt, and we'll do so if we have to, and if we can't resolve it in some other way.
Well, that is the usual routine, so
That's right, that's right.
nothing unusual there, is there?
I didn't suggest this meeting to posture, and I really don't think there's much to be gained by us getting into a discussion of the merits of the case. Really, the reason for my suggesting this meeting was to see if there was something we could do to help our clients avoid the entanglement of litigation, and see if there wasn't some way that they could resolve this dispute more quickly and less expensively than litigation. And the reason that this came to mind is because, as I understand it, there may be some interests here, both of your client and of my client, that may not be able to be well served in litigation and may be able to be better served through some alternative dispute resolution mechanism. But before we even continue, I just want to confirm with you that the discussions that we're going to have this afternoon, we'll treat them as confidential settlement discussions, and that nothing we say will be used in any litigation or any proceeding, just so that we can be frank with one another and hopefully have a productive dialogue.
Oh, I have no problem with that. Treating what we say here today as frank dialogue, I hope that it is, and I don't have any problem treating it as if it were settlement discussions. Let me ask you this, since you said we're going to be frank. Is there any likelihood that this case can be settled? That would be a new experience for me in this type of litigation.
Well, let me tell you why I think at least it may be worth a try in this case. My client's insurance policy has a $100,000 loss retention. That means, as you know, that the first $100,000 of legal fees and expenses is going to come out of my client's pocket. And in these financially trying times, that can make the difference between a profit and a loss for my client. And quite frankly, if they can avoid paying me a sizable portion of that sum and somehow resolve this dispute, they'd like to do so. They have a very practical reason for wanting to try and resolve this, which really has nothing whatsoever to do with the merits of the case.
Well, are you saying they want to pay it to us?
They don't want to pay it to you either, sir, no.
Well, what else
and they
is there
feel
for
that,
us?
you know, even if they win the case, they're still going to have to pay that money, and they'd like to try and avoid that if they can. And another more less tangible reason for their being willing to consider sitting down with Dr. Roark in some fashion and listening to him and hearing him out is that although they're confident the article is not defamatory and there was no fault and his reputation was not injured in any material respect, still they think he is probably justifiably enraged at the way he was treated by the reporter, that he's angry with the newspaper, that he received shoddy treatment from them. And they see no risk in listening to his side of the story and seeing if he has reasonable, legitimate concerns that they may be able to address in some fashion or another. That's the way my client sees it, and I might add that as I see it from your client's perspective, an ADR proceeding might have several advantages as well. My sense is that your client is more concerned with having his reputation rehabilitated than obtaining monetary relief. As a matter of fact, we don't really see that there's much in the way of monetary relief that he's going to be able to obtain, even if he's successful.
Well, I disagree with that position, you obviously
I'm sure you do, but, and I'll be, happy to hear you out, and I understand that you probably feel that there's much in the way of monetary damages that he can recover, but this is our perception. But more importantly than that is, to the extent that his real interest is rehabilitation of his reputation, that type of relief, as you know, is unavailable in litigation. And I'm not guaranteeing that it's available through an ADR procedure, or that the client would be willing to, to do, or what the client would be willing to do in that regard, but they are willing to listen to Dr. Roark and to see if there is perhaps a way to accommodate that concern, assuming that Dr. Roark is reasonable and that they can reach some kind of a meeting of the minds.
Well, it's interesting you say you don't want to posture and then tell me my case has no merit, my client has no damages. I'll tell you this, my case does have merit, my client does have damages, and I believe that I can submit this case to the jury on punitive damages because, as you know, this guy isn't the owner of the building. That's clearly false. As you further know, there is a strong implication in that story that he or the owner burned that building, and I think that there's no evidence to substantiate that, and this case is going to go to the jury, and you know this case is going to go to the jury. Or I wouldn't be sitting here, isn't that right?
No.
So what other kind of relief are we talking about?
Well,
are you going to print a retraction? Are you telling me that?
No, I'm not telling you we're going to print a retraction. I'm not telling you that we're going to print anything, but I'm telling you that we will consider possibly printing an article that might give Dr. Roark the kind of satisfaction that he may feel he needs.
What kind? I can't conceive of what kind of an article
well,
would give him that satisfaction, without saying that your article was wrong.
We don't think our article was wrong. We don't think our article was wrong.
I think the property records will show you that.
Well, he's a limited partner in the building.
Yeah,
that certainly makes him an owner in our view. I mean,
look,
it may be a jury question, it may not be a jury question, and that's something that we would see along the road. Even making a summary judgment is going to cost my client money. We're early on in the litigation here. We haven't done anything, essentially. My bill is relatively small, and you know how quickly, my bill can climb, just as yours can. You have done nothing except draft the complaint and haven't put a lot of time into the case either. And so there's a window of opportunity here from the point of view of my client's interest in trying to save some money to talk, that's all. That's the reason that we're here, at least from our perspective. And I don't know how much you know about alternative dispute resolution, whether you're familiar with what I'm referring to, but I can certainly explain to you what I'm talking about from a procedural point of view.
Well, I don't want to foreclose that, and I'm willing to listen to what you have to say, but I want to tell you a couple of things before we waste any time talking about it. You are correct that he would like to somehow rehabilitate his reputation. I frankly can't see how that could be done short of a retraction story. If you don't want to call it a retraction, that's all right. But it would require some sort of a story to indicate that the article was in error. Now, if you want to call it something other than a retraction, great. Secondly, it sounds to me like you're talking about some sort of a settlement that doesn't involve the payment of money. He's going to have to pay me one way or another. As I've told you in my letter, I have a contingent fee contract. Clearly, you're correct. At this juncture, I don't have a lot of work in it. I am willing to work out some accommodation to my client on that fee, but your client's going to have to pay whatever that is. So some money is going to have to change hands. And beyond that, this vague relief you're talking about in the form of a rehabilitation of his reputation eludes me, but I'll listen to what you have to say about it.
All right. Well, I think, the ultimate form of any settlement, if there is to be a settlement, would have to be worked out by the parties, obviously. If, in fact, my client was convinced that there was an error of some sort, a misunderstanding in terms of any of the facts set forth or statements made in the article, there are ways, I understand, that there can be a correction, so to speak, and Dr. Roark's side of the story can be presented without it being a retraction.
Corrections are better than retractions? Okay.
Well,
we'll take a correction.
Without calling it a correction either. What's important, look, quite honestly, what's important to them is another factor, and that's that there be no linkage between a lawsuit and anything that they might print in the paper. You can understand that. They're a media defendant. They get sued all the time. People call up and complain about articles all the time. And their inclination, and it's an inclination here too, I have to be honest with you, is to dig in their heels and tough it out because they're confident that they'll win. But there are these other interests, as I mentioned, and I think a discussion between your client and a representative of my client, might enable them to come up with something that could satisfy the interests and the needs of both of them. As far as money is concerned, I can't tell you as we sit here that my client is willing to pay money. I can't tell you that they're not, if they were convinced that it was in their interest to do so, to resolve this thing now, that they wouldn't be able to pay. They wouldn't be willing to pay some amount of money. Again, the purpose of our being here today is not to settle this and not to agree on a sum or a form of settlement. It's to discuss whether there isn't perhaps a mechanism whereby the parties can try and resolve this in a way that's going to be less stressful to your client, certainly. I've heard in the community, for example, that his health isn't the best, and he may not even be able to withstand the strains of this type of litigation. That's my purpose for calling this meeting, and let me explain to you how the procedure might go, and maybe you'll have a better understanding.
Are we talking about some sort of an arbitration procedure?
Well, not really arbitration. Arbitration is a binding procedure, typically.
Then we're not talking about that.
No, and I'm not suggesting a binding procedure, because I would assume that even from your client's perspective, if there's a binding procedure, you'd rather be before a jury than an arbitrator.
Sure, that's right.
Okay. And we're talking about a non-binding procedure where the parties, which would facilitate the parties' ability to fashion their own solution. It wouldn't be a solution imposed by a third party. Mediation, I don't know if you were familiar with that.
Well, not really. I've seen the term in the literature, but I've never used it.
At this point, Dana explained the non-binding methods of dispute resolution that she had emphasized earlier with Charlie, mediation and the mini-trial. And she proposed the customized process she had recommended to her client, a mini-trial with the option of using the neutral advisor as a mediator.
Let me ask you a few questions about it, and I'm at a disadvantage, I confess, because I know you do a lot of this, and as I told you, I have done none. Is there a time when these are typically done? Do these come before or after discovery, or is that just flexible?
It's very flexible, and it depends on the type of case. In very complex, highly technical cases where you absolutely need to determine certain facts before you can evaluate or even present your case, there will be, and there can be, some minimal expedited discovery. You try to avoid the type of federal rules of civil procedure or state court discovery. That's the whole purpose of this procedure. But discovery can be available in these proceedings, if the parties agree.
Well, you see, my problem in this case is that it would be difficult for me to make my strongest presentation until I know what investigation was done by that reporter to come to the erroneous conclusion that he was the owner, that Dr. Roark was the owner. And further, I would like to know whether, in fact, a source at the fire marshal's office, in fact, relayed the information that was reported. And without that information, it's difficult for me to make my strongest presentation, and I would be allowed to do that, obviously, prior to a trial.
Right, I understand that. I think here, in this case, we would probably not be amenable to having discovery of the reporter, certainly not disclosing the source. It would defeat the whole purpose of our going through the proceeding at this early stage. I mean, for me to begin to represent the clients in connection with discovery is going to eat up the money quite rapidly. And I really don't. I think you're going to summarize your case. You can assume the facts. You know the facts, at least from your side, or so you say. I don't think it's really going to hamper your presentation of the case for this particular kind of proceeding.
Well, let me give you an example. If I find out, for example, that the reporter, in fact, did do the proper investigation and discovered that the Landmark partnership owned that building and knew that Dr. Roark didn't own the partnership, then obviously the case is a great deal stronger because he intentionally misled the the public in that article. If, on the other hand, he did no investigation, obviously my position is not quite as strong. And how could I make a realistic presentation without knowing which way it was?
Well, nothing forecloses you from doing your own investigation, first of all, prior to this proceeding, to see what you can learn on your own. We might consider, and I'll have to talk to my client about this, and you and I may have to discuss this again, we might consider stipulating to one or two facts if they really are critical for purposes of this proceeding only, to help you along in that regard, if indeed an advisory opinion is going to be sought from the neutral. That would be one of the prime reasons why you might want some additional information. But I can't, at this particular juncture, I'm not free to agree to any discovery, as the term is used, but we may be able to work something out.
Along the same lines, when would you contemplate that this process would take place? Are we talking about soon?
Well, yeah, I think, as you know, I think our answer is due in 2 weeks, and what I'd like to do is get it going before we put more time into this case. That's what makes it desirable from my client's point of view. And I would be in a position to draft an agreement so that you can see more precisely exactly at least what I have in mind, and we can talk about it and see where you may have a problem with one or more provisions. I also have a number of articles and some other information that may be helpful to you that explains some actual experiences that other lawyers have had with similar types of cases and similar types of procedures that may be of interest to you as well.
Well, that would be helpful to me. I made a note here as you were talking that I'd like to see whatever literature you might have, because I'm totally uneducated about the subject. Do we draft the rules of the game before we play it, you and I?
We draft the rules of the game.
So that we both know what's going to happen before it does?
Exactly, how it's
going to play out. At that point, I can then make a decision if there's something I don't feel I can handle.
Absolutely, absolutely. And at that point, the other information I'm sending you may give you some comfort in the sense that you can see that this has been done before and what the results have been. And there are a few lawyers in town who I have worked with in your position on the other side in these procedures, and I can give you their names.
Well, I'd appreciate that. I'd like to know. It's a new field, and as you know, lawyers are always afraid of something new. And that would be helpful to me if you do that. I guess to answer your question, basically, I have no problem in talking. I never want to foreclose an opportunity to settle a case, and I know that regardless of how strong a media case is, all of them are subject to being reversed on appeal. That happens often, and I'm certainly willing to talk to my client and recommend we do it. As I see it, it's a no-lose proposition for us. As you say, it's not binding.
That's right.
Basically, we'll lose a little time, and if we're lucky, we'll gain a great deal, won't we?
I think we might.
Notice how the newspaper's lawyer showed strength and flexibility simultaneously. She demonstrated her command of the law and her confidence in her case, and at the same time she stressed the underlying interests of both clients. In addition, she paid close attention to the opposing lawyer's needs, and especially his need for certain information that could be gathered in discovery. In another case, of course, the issues and needs of the parties might have called for a different method of dispute resolution. Sometimes there are good reasons for one or both of the parties to prefer litigation. That's why I like to think that ADR should not stand for alternative dispute resolution, but appropriate dispute resolution, and that the lawyer's objective should be to help the client select the best process for dealing with a dispute. Once that is accomplished, the lawyer should help make the process work for the benefit of the client.